Welcome. Mary Schmidt is a Friday Harbor attorney who has practiced bankruptcy law for 28 years. Mary assisted over 2,500 individuals and businesses with bankruptcy during the last economic crisis. She offers a free consultation regarding whether to file for bankruptcy. You can find her contact information at www.islandbankruptcylaw.com. Without further ado, thank you, Mary Schmidt, for coming and for telling us about this. We're on.
All right, thank you. I'm going to talk about when you should consider filing a bankruptcy. If you own your own business and you are affected by the current pandemic or any other emergency such as an earthquake or a war or anything like that, or you are unemployed due to an economic crisis, you might consider filing a bankruptcy to protect your assets and get relief from your creditors due to the circumstances. Because bankruptcy can have serious long-term financial and legal consequences, including loss of your property, you should hire an attorney and carefully consider all of your options before you file. Many attorneys do give free consultations, and I do give free consultations. Only an attorney can give you legal advice about what can happen as a result of filing for bankruptcy and what your options are. If you do file for bankruptcy, an attorney can help you fill out the forms properly and protect you, your family, your business, your home, and your possessions. Although the law allows you to represent yourself in bankruptcy court, you should understand that many people find it difficult to represent themselves successfully. The rules are technical, and a mistake or inaction may harm you. If you file without an attorney, you are still responsible for knowing and following all of the legal requirements. And I can tell you, after 28 years of bankruptcy practice, that the printed bankruptcy code, Title 11 of the United States Code, with all of the federal rules of procedure and local bankruptcy rules and the statutes for Title 11 is about 6 inches thick. So it takes a long time to really gain a thorough understanding of the bankruptcy statutes and the process or how to use them. You should not file for bankruptcy if you are not eligible to file or if you do not intend to file the necessary documents. The court takes very seriously bankruptcy fraud. It is considered a crime, and you could be fined or imprisoned if you commit fraud in your bankruptcy case. Making a false statement, concealing property, or obtaining money or property by fraud in connection with the bankruptcy case can result in fines up to $250,000 or imprisonment for up to 20 years or both, pursuant to the code. So basically, what that means, all of this means, is that when you're filing a bankruptcy, although the process, maybe the paperwork, you may be able to fill out the paperwork, you might not be able to do it properly, and you could face serious consequences. And that's why it's important that you gather all of your creditors and know what your assets are before you decide to proceed. There are many levels of legal analysis that go into a bankruptcy. One of the most important, especially during this economic crisis, is the timing of the case. Each case is unique, and it's important to determine, based on the issues involved in each person's bankruptcy case or each business's case, when the case should be filed. And secondly, it's very important to determine whether the debtor, the individual or business, is eligible to file a certain chapter of bankruptcy. It's all about protecting your assets, the way I look at it, because you want to get debt relief and not have to pay your creditors due to the circumstances, but you also want to protect as many of your assets as possible. And so I really take a proactive I take proactive steps to make sure that we protect your assets. And there are certain things you can do legally to make sure you avoid any major assets that you might have. So that's why I recommend that you get a consultation. And I don't recommend that you wait until you start getting judgments against you, or until you are feeling like you have zero income, or you're selling off properties, or you're depleting your retirement accounts. Then it's almost too late, because you create tax issues, and you have to report your income within the 6 months prior to filing, and that might skew your case. If you have sold property and have income, or you have money in the bank that you cannot protect any longer because you've converted it from, say, real property to cash. So these are all items that are necessary to consider when you file. And that's why, as soon as you're starting to feel like there may be a possibility that you won't meet your monthly living expenses, or pay creditors, or meet your business expenses, then you should seek a consultation, and because so that you're well informed about what decisions you should be making in the future. And again, I like to stress, it's all about timing of the case, and it's about protecting the assets you have. Now, if you don't, say you own your business property and you have enough savings to carry you through about a year of having no income, um, there's a possibility that you might even just close your business and take off a year, because you are not obligated under a lease as long as you can pay your real estate taxes and just your general expenses with the business. You may end up laying everybody off and closing your business for a year and reopening. That is another option, and that's an option that I remember from law school from 1992, where my bankruptcy law professor mentioned that sometimes it's better just to close down and then reopen in a year. Now, some people want to keep their businesses open, and they have lease obligations, and they want to make every effort to stay open, but it is also an option just to close down. So do you have any questions about the timing, or when people should seek their consultation, their original consultation for bankruptcy?
Well, one question that comes to mind, and I think it might be something that would dissuade people from seeking help early. And you mentioned that a lot of bankruptcy lawyers offer a free initial consultation.
Mm-hmm.
But uh, one thing I think a lot of people might be wondering is, that, okay, how does, if you're deep into debt and needing bankruptcy protection, how does the lawyer get paid?
Okay. Well, yes. So the way I can explain how I get paid and other attorneys, and it's different from each chapter. So I can tell you about the costs, and I will get to the costs for each chapter um, as we go along. But if you're at chapter 7 and you decide you're just going to close everything down and file a chapter 7, then I normally take cash up front. So you need to start saving. If you're planning on a bankruptcy for chapter 7, you need to save about $2,000 to complete your chapter 7. And again, it depends on what kind of work that I would have to do, because if you have judgments and I have to avoid liens, then there's extra charges. So that's why, another reason why it's very important to get a consultation right in the beginning, because that'll save you money in the long run. If you every time I have to avoid a judgment lien, it's $450. So if you get into your bankruptcy before you get judgments, you're going to save quite a bit of money. And I can go into further detail as I go through each case. And basically I just get paid cash up front. It's a flat fee for a chapter 7. It's different for 13s and 11s and 12 and subchapter 5s and 12s, because there are plans for payment.
Okay, well, we can talk about those then. It's really good to know about that that advice about starting before you're really hurting, um, or starting to plan before you're really hurting is really, really good, because I think a lot of people might be thinking of it as sort of the end of things, like when you're like at your last resort, and it sounds like it's really clear that it's you've got to be well ahead of it being your last resort.
Exactly. And the other point is that if a lot of people are dedicated to their employees and want to keep them on as long as they can. And unfortunately, though, you put all the money into the payroll, but then you don't pay the payroll tax, and that creates a non-dischargeable debt. Or you get into the position where you can't pay payroll, and then what happens is that becomes a non-dischargeable debt. So you really have to, when you feel you're not going to be making it with your business due to the emergency circumstances, you really have to take action sooner than later. So that is an important point. So with that, I'd like to move on because we have a limited time. I'd like to move on and talk about the different chapters of bankruptcy. Is that all right, Mickey?
That sounds great. Thank you.
Thank you. So chapter 7 is the total liquidation bankruptcy. It's the one that most people are familiar with. It's the fresh start bankruptcy. And it is a 90-day process. And after 90 days, and it's a 90-day process from the date of filing of the petition. And when you file your petition, that invokes Section 362 automatic stay, which stays your creditors from proceeding against you and your co-debtors. And then after that, then the bankruptcy process goes through for 90 days. After 45 days, you have a meeting of creditors, and then you wait another 45 days. And if everything goes well and the trustee doesn't find any assets, then you get an order of discharge for your unsecured debt. And we talked about there are different levels of claims in a Chapter 7 bankruptcy, and in fact, different levels of claims for all bankruptcies. So you have your general unsecured debt, such as credit card debt, medical expenses. They would be your lease expenses, and any kind of personal loans, family loans, and so any kind of anything that doesn't have a lien or UCC1, or any kind of and anything that doesn't have a judgment, any creditor that doesn't have a judgment against you. So then you have your priority claims, and priority claims that are non-dischargeable are, and this is for every case. Let's see. Priority claims are non-dischargeable: domestic support obligations, most student loans, but that may change. Now, a lot of this may change if there is a change in the administration in Washington, D.C. in November. The first thing they're going to do is address the issue of educational loans. So then you have certain taxes are non-dischargeable, but however, some taxes are dischargeable. So that's another important reason to go see an attorney, because a lot of people will miss that. Debts for fraud or theft are most likely non-dischargeable, but again, there are exceptions. Debts for fraud or defalcation while acting in a fiduciary capacity, and most criminal fines and restitution obligations are non-dischargeable, and debts that are not listed in your bankruptcy paperwork are non-dischargeable. And debts for acts that cause death or personal injury, such as car accidents involving a DUI, and certain long-term secured debts, such as mortgages, are non-dischargeable. First mortgages, unless you surrender the property. So there's a lot of non-dischargeability issues in the bankruptcy code. However, there are also a lot of exceptions to those claims that are non-dischargeable. So Chapter 7 is the Fresh Start program. The filing fee is $335, and I charge $1,800 for the Chapter 7. There's also a credit report fee. A joint credit report is $74. I'm required by law to run a credit report. And then a single credit report is $37. Another thing that people filing are required to do is they have to get a certificate of credit counseling before they file. And then after they file, they have to do a personal financial management course, or you will not get a order of discharge in the end. So that's a basic rundown of Chapter 7. Did you understand what I said? Are there any questions?
I think that's really clear and helpful. One thing I think you mentioned unsecured and priority, um,
Mhm.
and I assume the other category would be something like secured ones where you have collateral for your
Oh,
debts.
yes. Thank you. Yes, so the secured creditors are your car loan, and they are your mortgages or anything that has collateral. So collateral would be like a vehicle. It would be your personal property. If you put up personal property for if you gave somebody a security interest in your personal property, or you engaged a factoring company, which is a really bad idea if you're having financial trouble, and they have a security interest in your accounts receivables or your inventory, that often causes problems in bankruptcies.
What's
So
a
yes, those
factoring
are
company?
a factoring company. You put up your account. They are lenders, okay?
Hmm.
So what happens is people try to save their businesses and they go to these hard money lenders. And a factoring company, in order to give you money, they take security interest in your accounts receivables and your inventory. And so what happens is a lot of people will, when their business is going down, they'll sell off their assets without paying the factoring company. So then they have to turn that money over to the factoring company, and it becomes a non-dischargeable debt because they were secured by the accounts receivables. So you have to watch the people who are offering you money when you are in a financial, um, when you're in a financial strait, because you you end up signing things away without thinking about it, and then it will come back to haunt you in a future bankruptcy. Okay, because maybe you could have exempted, say you borrowed $10,000 from a factoring company and gave them a security interest in some kind of restaurant equipment, and so then you decide that you're going to close and close for a year and reopen. Well, basically given away your restaurant equipment that you could have used in the future, as an example, because you can exempt about $10,000 dollars worth of equipment in your bankruptcy. But if you give a security interest over to a factoring company, then you've lost that because they have a right to take that and sell it. Okay? Any other questions?
Thank you. No, that's okay.
Okay, and that explanation about the creditors, the types of creditors, relates to all the chapters. So I won't be speaking about that again unless you have a question. So Chapter 13 is the repayment plan for individuals with regular income, or also small business owners that are sole proprietors. And basically the fee on that, the filing fee is $310. And the court sets our fees in the Chapter 13 plan because it's a reorganization plan. And those fees right now are set, those original fees are set at $4,000. So, and the goal, but I only take $1,500 up front, so that because I know people are strapped, and so then the rest is paid through the plan. And the goal of a Chapter 13 is to reorganize your debt. It's like a corporate Chapter 11 for individuals and sole proprietors. And basically, we create a plan that has to be approved by the court, and the statute sets the parameters of the plan. It has to be a feasible plan, and we present it to creditors, and we can draw objections, say, from the Department of Revenue is a major one that comes to mind, because if you haven't paid your state taxes, they take an interest in your case and recommend whether or not it should be approved. And so if all the creditors approve of your plan, you can have a 36 to 60 month plan, depending on your income, disposable income. And, and all you have to do is make that payment every month. And at the end, you get an order of discharge of any of the creditors you hadn't paid. Okay? You can also surrender property. You can avoid leases. You can avoid contracts in your Chapter 13 plan.
What happens then if you're not able to make that payment? Like if your business is in bankruptcy and you're not making any income?
Okay, so then if you don't have if you don't have disposable income, you can't do a 13. You'd have to do a 7. But if you do have some disposable income and you want to be in a Chapter 13 because, for instance, you fell behind on your mortgage payment because you were trying to fund your business, you can work to bring your mortgage current in a 13 with any income that you might have, and get a benefit of the discharge. You would basically get a Chapter 7 discharge of the other unsecured debt at the end of the Chapter 13. So Chapter 13 is very complicated. And okay, so let me run now to the Chapter 11. Chapter 11 is a reorganization plan for corporations. It's much more expensive, and it is the filing fee is $1,717. Attorney's fees are going to run $10,000. You're going to need at least half of that up front, and it's for large businesses. And I try not to do Chapter 11s because they're monthly fees, because you're working with the U.S. Attorney's Office and you have to file all sorts of reports. So they charge you for filing those reports, and they're usually running $300 to $400 a month just to do that. Then you have to, just like in the Chapter 13, you have to create a plan, but there's many more disclosure requirements. So I really don't think that anyone in that very few people in Friday Harbor will have a corporation that's large enough to require a Chapter 11. Okay, and I try to avoid Chapter 11s at all costs because they are so complicated for people to comply with the plan. Right now we have, and I previously did a talk on subchapter 5 of Chapter 11, which is the new small business bankruptcy. A reorganization plan is still required, just like in 11, but it's streamlined. There are fewer reporting requirements and less costs than a corporate 11. And there's also this potential to discharge a second mortgage on personal real property if mortgage proceeds were used exclusively for small businesses. And the subchapter 5 of Chapter 11 is available to LLCs, S corps, and sole proprietorships if the entity meets the qualification of the subchapter 5. Okay. And yes. Any questions on that and on 11 or subchapter 5?
Well, actually, a little bit broader than that. So you mentioned the LLC. So can LLCs go with the Chapter 7 or Chapter 13 as well, or just the subchapter 5 of Chapter 11?
Good question. The LLC cannot do a 13 because they're not an individual. Okay, so they can either do a Chapter 7, which would be the total liquidation chapter, or they can do a subchapter 5 of Chapter 11. And if they're large enough, like a big real estate company or something, then they might do a regular Chapter 11. Okay. The LLCs, and what I did during the last economic crisis is, if your LLC files a Chapter 7, then it never gets a discharge. A corporation that files a 7 never gets a discharge because it's the lack of the discharge is to protect creditors in the event that the LLC reopens. Okay, because they don't want LLCs discharging everybody and then, the next month setting up again under a different name and doing the same sort of business without having without giving some rights to creditors that were discharged. So you have to be careful about filing a 7 with an LLC. Okay, you're better off trying to do a reorganization, subchapter 5.
It's really good.
However, or as an LLC, if you decide you're never going to go into this business again, you can certainly do a chapter 7. The other thing that many people did, especially in the construction industry during the last economic crisis, was they just closed their LLCs, and when you close your LLC, the debt drops down to the sole proprietor, to the individual. And so what they did is close their LLCs and they just filed a personal bankruptcy instead of filing 2 separate ones, which saves you a bit of money and also allows you to avoid that lack of discharge of that debt. Okay.
That sounds like a interesting option.
Right. So then we have the chapter 12. And this chapter is related to farmers and fishermen, and basically it's the same as the chapter 13, but it is related to family farmers and fishermen because they have to protect their crops and their equipment. So there's more, but they're not big enough to file a regular chapter 11. So maybe more farmers and fishermen might opt for subchapter 5. Okay. So I think that is all I had on any other questions. I tried to rush through that. I don't know how we are on time.
I think we still have a couple more minutes, so I think it'll be just a couple. So that seemed like a really good overview of the whole thing. One thing I was still wondering about was if you close your business. Well, I think you covered that in terms of the LLC. That if you close your business, the debt drops down to the individual.
Mm-hmm.
If you close it temporarily, does that make a difference, or is that just a matter of being able to reduce your bleed of funds until the economy improves and you can start making money again?
Right. Well, you can do that. If you can afford to pay, if you own your business location or you strike a deal with your landlord so that you don't accrue rent, then you can just close down for a few months and then reopen. And you probably could either work with your creditors, like your unsecured credit card debt and things, to see if they won't postpone payment. Or you can close down temporarily, and file a chapter 13 or a chapter 7 and then reopen. Certainly you can keep your business open while you are in bankruptcy, so you don't have to worry about filing a bankruptcy and then having to close your business. But I think that if you can negotiate, I think the landlord issue and the lease payments are every business's, especially up here, probably every business's largest debt, and so their largest contractual obligation. So if you can negotiate with your landlord, close the business for a few months, and reopen when you think like during the winter you could close and then reopen in the spring again, maybe that would keep you out of a bankruptcy. I mean, those are all options that are unique to each individual case. Those are the sort of things that I talk about in my free consultation, because each business is different.
I think we're running out of time, but that's a really helpful overview, and we really appreciate your coming and telling us about this. We'll put this up online, unless there's anything more you wanted to say before we go.
No, thank you very much for having me talk about bankruptcy, and I'd be happy to talk about it in more detail at another time as well.
Okay, and like I was about to say, we'll put this up online, and if people who see the video want to send us questions, then maybe we can, if there's enough of them, maybe we could put together another interview at some point or presentation at some point if there's questions on a particular topic, if that's okay with you.
No, that's fine. Thanks again.